Good afternoon, ladies and gentlemen. Welcome to Civil Justice Subcommittee for Tuesday, February the 14th, 2023. Madam Clerk, please call the roll.
Representatives Beck, Bolso,
Here.
Capley, Eldridge, Farmer, Grills, Lamberth, Parkinson, Todd, and Chairman Russell. Chairman, you have a quorum.
Thank you. Members, are there any personal orders this afternoon? No personal orders. So I'd like to begin today by telling you that last week, if you noticed, I didn't recognize each individual member, and I did that on purpose because I wanted to try something new this year and just to see how it works. So each week I'd like to introduce two members to tell a little bit about themselves, and this will be a weekly reminder that we are representatives of the people and come from different backgrounds. And I'll sort of tell you about myself first. I was elected in 2018. I'm from the 21st District, which is Monroe and Loudoun counties. I was a Tennessee State Trooper before doing this, and unfortunately was hit by a tractor trailer up there on I-40 in West Knoxville. And after 5.5 years of physical therapy, the doctor said, well, you can't go back doing that again. So I looked for a new way to serve, and here I am. And I sort of tell you that for a couple of reasons. Is if you're on my far right and left and I don't see you, it's because my neck is all fused up. So if I don't see you to be recognized, sort of TJ or Courtney here will be looking for you. And if I mispronounce a name, and I promise you I'm going to, the left side of my vocal cords are still partially paralyzed from that crash, and I mispronounced your name last week, Representative Bolso, and I apologize for that. And I went to you after the fact and apologized. I just want to make sure I did that again. And I misread Taylor Overton's name, and just want to say sorry about that too. But so this week I'd like to ask Representative Parkinson if you would sort of tell about yourself and what year you was elected and what you do and whatever else you want to say.
Okay, thank you to my gavel-wielding chairman, who's obviously been lifting weights lately. You know, I truly appreciate it. Truly appreciate serving on this committee. And I am Representative Antonio Parkinson, and I was elected in a special election in 2011 after the passing of my predecessor, State Representative Ulysses Jones. And I'm originally from Oakland, California. I grew up in Los Angeles, finished high school in Texas. And when I tell people that, they say, oh, your parents were military, huh? I said, nah, we were just unstable. And so we bounced around a little bit. But I got to Tennessee via the Marine Corps, and y'all been stuck with me ever since. So any of the bad things that you either hear about me or know about me, blame it on the Marine Corps. So, you know, if you hear any expletives, blame it on the Marine Corps. You know, and I up until recently, I had been probably the most ruled out of order person in the legislature. You know, I got a little competition with these new members that have come on board. So, you know, look forward to having a great session. And thank you, Chairman. I appreciate everything you did and all your service, prior to now too. Also, thank you.
Thank you. And I do have a question for you. Are you a San Diego Marine or a Parris Island Marine?
I am a Hollywood Marine, a.k.a. San Diego. Yes, sir. Thank you.
Thank you for your service. And Representative Eldridge, would you like to tell a little bit about yourself?
Thank you, Chairman. I'm Rick Eldridge. I represent the 10th District up in East Tennessee, which includes Granger County and most of Hamlin County. And I was elected. I came in with Chairman Russell in 2018. I had served on the county commission for 8 years in Hamlin County before this. My business background, I run a glass company. I owned a glass business for 33 years. If you need a window fixed, I can probably take care of it. But someone asked me the other day about something else, and I said, well, you're going to have to call Holtzclaw about getting a ring sized or something like that. So, but that's my background. Family, I have two kids and 7 grandkids, and I have a new great-grandson. And it's been a pleasure and an honor to serve here for the people up in my district. Thank you.
Thank you, Representative Eldridge. I'm fortunate enough to chair this great committee and work alongside some great legislators that will give us an opportunity to look at each bill uniquely and with that give the utmost consideration to every bill that comes through this committee. I always remind people that every bill that's filed and comes before us is important to somebody or it wouldn't be here. So with that, we have 12 bills on our calendar for the committee today. And before we get started, item number 12, House Bill 795 by Representative Capley is rolled 2 weeks. And item number 4, House Bill 578 by Representative Bricken is rolled 1 week. And we're going to take item number 3, House Bill 1307 by Representative Kumar out of order. We'll hear his bill first. And we got a motion and we got a second. Representative Kumar, you are recognized on House Bill 1307.
Thank you, Mr. Chairman.
I'm sorry. Okay. I accidentally cut your microphone off. You're good.
Thank you. Mr. Chairman, as you remember, this bill passed through Civil Justice Sub and Full Committee last year, but there was some confusion in finance and it was placed behind the budget despite funding. So we're bringing it back. There is really no change in the substance of it. And for members, of course, who were not here last year, the premise is that since we have constitutional carry, so people can purchase a gun, and after meeting certain requirements, they can carry the weapon, the firearm. And so a mandatory gun safety course is no longer required. And I thought from a public health standpoint of view, that is very important. And I did speak with the governor and got funding for it. And what this bill does is it supplements $30 for each gun safety course that is given by a school that is approved, gun safety training school that is approved by our Department of Safety. Most of these courses cost around $32 to $40. So yes, there is a small copay the person will pay. Each of the firearm sellers will have a sign in their shop that tells people that gun safety course is available. State will pay $30, and of course, they will pay the rest. And gun purchase is not a requirement because even if somebody's not buying a gun at that time, but they see this and they want to take advantage of the supplement from the state as well as take a gun safety course, I think that will be good for our public in general. With that, Mr. Chairman, I'll be happy to answer any questions.
Thank you, Representative Kumar. Any questions for Representative Kumar? Seeing none, are we ready? Representative Grills.
Thank you, Mr. Chairman. Chairman Kumar, run that by me one more time on how you're supposed to apply for the $30 or how the voucher, I'm assuming?
It will not be a
Kumar,
voucher. The payment will go directly to the gun safety school that administers that. And there's a sign at the place where firearms are sold, and a person can based on that, they either gun safety training is available at that location, or the person will be referred to an approved gun safety course where they can go ahead and make use of it.
Representative Grills, you're recognized.
So would that school be responsible for recouping the money from the government, or how would that work?
The Department of Safety has a Thank you, sorry. Department of Safety has a method by which they will reimburse the school.
Representative Grills.
Thank you, Mr. Chairman. And do you feel that this might drive up the cost for those that do not get the voucher, so to speak, and maybe cost more for someone like myself that may not use that voucher? And could that potentially drive up the cost for those?
Representative Kumar.
Thank you. I don't really think so, in the sense that it is known what the cost actually is, and with the availability of supplement, our hope is that more people will get gun safety training, and after 1 year, we will know. Whether that happens or not, but our hope and expectation is that more people will have gun safety training, and I think that will be good for us.
Representative Grills.
Thank you, Mr. Chairman. I appreciate your efforts, and I too wish that everyone had proper gun training, but I do not necessarily like the idea of creating a voucher system for those that may want to. That's just a personal preference. Love you, love the tie, and happy Valentine's Day.
Thank you.
All right. Any other questions? Representative Todd.
Thank you, Mr. Chairman. Pulling funds from the handgun reserve is something that I think is a good thing to do, but I think it's good to establish where those funds came from. So basically, as my understanding from meetings and discussion with the department and then looking at fiscal notes and putting all these things together, that reserve fund has accumulated because they've overcharged handgun carry permit holders for the fees and the costs associated with that. And that's just one of those things that's kind of hard to do, how to know what the costs are going to be up front. You set a price, and then you realize later that you're actually accumulating a profit, in this case, a reserve fund. So I think returning that to the rightful owners, the folks that paid those permit fees, is positive. And I think your bill would catch some of those, but primarily I would imagine you're going to get folks that probably weren't involved in the handgun carry permit at all. This would be for, if you could just explain and make sure that I know exactly the parameters of this, who all could this touch? Is it anyone that applies or only permit holders?
Representative Kumar.
Anyone that applies. So we wanted to make it widely available to people.
Representative Todd.
Thank you, Mr. Chairman. And that would be a concern I have, is that, again, we're taking money that permit holders put into the system over and above the cost, and allowing folks that have not put anything in the system, into the handgun reserve fund, to benefit from it. I also am concerned, as Representative Grills was, that if a course costs $30 today and the state through this reserve fund is going to pay $30, then probably all those courses are going to go up in cost. If those folks putting on those courses know, there's $30 guaranteed, and folks will pay the difference, then I'm concerned it's going to drive the market cost of that up. And certainly the demand, if the demand goes up, it's going to drive cost up as well. And then it may not have the desired effect other than drawing down that reserve fund. Thank you, Mr. Chairman.
Representative Kumar.
Regarding the reserve fund, you're right, it belongs to the people, but to return it, even if we were to, as you have considered, making not charging permit fees anymore, it's not going to go to exactly the same people, because they will be different people. So it's not possible to return it to exactly the same people, but I think the idea is to use it generally for improving the awareness and gun safety situation within our society. And I think we spend a lot of money on decreasing crime, and this will be one way to avoid horrible tragedies and accidents. I think from that point of view, it's very good use of the money. And I agree with you. Regarding possibly costs going up, I think the chance of that is small, because these are schools that are approved by the Department of Safety, and they monitor the costs in that sense. So I don't think that costs will go up that much. And I really look forward to 1 year later getting a report back and finding out that we really did make a difference. We did increase the number of courses that were given in the state. Thank you, Mr. Chairman.
Representative Todd, any follow-up? Representative Bullzo.
Thank you, Mr. Chairman. If I could, Representative Kumar, let me follow up on Representative Todd's point, which I understand to be that perhaps it would be better to return these funds, these excess funds from the permit reserve, to gun owners versus using them in this gun safety program. And one of the points that you made is that you couldn't return the funds to the same people that paid them, because obviously they already have their permit, they already have their firearm. But in the law, there's this concept of something called a fluid class recovery, such that if you have taxi cabs, for example, overcharging customers, the way courts have dealt with that historically is they require the taxi cab company to lower their rates for some period of time to make up for the overcharge. So you're not actually refunding to the people who paid the overcharge the exact same amount, but it is a fluid class of customers in the taxi business and also here in Tennessee gun owners. And I think this is a particularly significant point that Representative Todd is making, because at one level, this issue concerns a fundamental constitutional right under the Second Amendment. And obviously, the state doesn't impose a fee for someone to exercise the right of free expression under the First Amendment, or the free exercise of religion under the First Amendment, or the right to peaceably assemble under the First Amendment. But historically, there has been this price that's been taken away from those who exercise their Second Amendment to get a permit. And one of our former Chief Justices famously said in a case called Maryland versus McCullough in 1819 that the power to tax is the power to destroy. And here, when we're exacting a price from citizens to exercise their Second Amendment, that certainly runs counter to the amendment's provision that the right to keep and bear arms not be infringed. So my question simply would be, why isn't Representative Todd correct that a better use of these funds would be to refund them through a fluid class recovery to future gun owners, rather than to use them for this very laudable gun safety class that you're proposing?
Representative Kumar.
I have told Chairman Todd that I would be happy to support that bill if he brings legislation to disperse those funds in the way that he thinks, and I think so. But I think there is about a little over $24 million in funds there, and I think $1 million out of that to be used for gun safety courses and enhancing gun safety in our state is also a very, very good use. And I told him that out of the 24, if this bill was to take $1 million, the other was to take $23 million, that's still a good deal.
Representative Bozo.
Thank you, Mr. Chairman. Nothing further. Thank you, Representative Kumar.
Thank you.
Representative Kepley.
Thank you, Mr. Chairman. Representative Kumar, are firearms instructors who are not certified by the state eligible to participate in this program for the vouchers, or?
Representative Kumar.
This is because the program is going to be run by the Department of Safety, so it will be schools that are approved by the Department of Safety. And believe it or not, there are 220 of them in our state. So it's widely available.
Representative Kepley.
So, no.
Representative Kumar.
The program will be administered only through approved safety courses, schools, so that what safety training is given is also approved by the Department of Safety.
So they have to be state certified, correct?
Yes.
Okay. Thank you, Mr. Chairman.
All right. Any other questions? Seeing none, we're voting on House Bill 1307, item number 3, to send to full civil. All those in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Congratulations, full civil.
Thank you, Mr. Chairman and committee.
If you want to be recognized as a no vote, get with the clerk. All right, next up is item number 1, HJR 131 by Representative Garrett. We got a motion and a second.
Thank you, Mr. Chairman and committee. Appreciate your time. You have House Joint Resolution 131 in front of you. What that resolution talks about is the full faith and credit clause of the United States Constitution and the Second Amendment. The reason why I believe this is an important resolution to bring forth to this General Assembly is a couple of reasons. One, Tennesseans travel across this great country. And as we know, there's states that further restrict rights under the Second Amendment, and there's some states that believe, like Tennessee, that those rights cannot be infringed by any government whatsoever in the Second Amendment. So why is this important? Why do we need this? If a Tennessean is sued by someone that's not a resident of the state of Tennessee or find themselves in another state and they're sued here, there is a potential for that state's law to prevail in Tennessee state's court. So what this does, under the full faith and credit clause, we are required to honor those laws of other states, unless it's public policy in the state of Tennessee to not follow those laws, that we would rather have Tennessee laws apply to Tennesseans. Therefore, this resolution establishes the public policy in this state that if any other law applies here in the jurisdiction of the state of Tennessee, that the public policy here is those Second Amendment rights cannot be infringed, and we hold those dear. That's what my constituents tell me. That's what I believe. That's what the public policy of this state should be. So therefore, if there's an argument to be made that the full faith and credit clause is invoked and another state's law will apply, the full faith and credit clause does not apply as long as we have public policy that we can point to that says it should not. That's what this resolution does. I'll be happy to take any questions. Otherwise, I would ask for your support and passage.
Thank you, Representative Garrett. Any questions for Representative Garrett? Representative Todd.
I'll just say I really appreciate you bringing this. This is in an area that I am not an expert at all, and I know you have seen what's going on in other states and are trying to protect our state from this and our state laws and our citizens first and foremost, and I just appreciate you bringing this. Thank you.
Thank you, Chairman Todd.
Representative Garrett, any further? Seeing no other. Representative Parkinson.
So what are we doing now?
Representative Garrett.
It's a good question. Representative Parkinson, I appreciate that. If a Tennessean is sued here and they have some action they took place in another state that has the same ideals that we hold dear to the Second Amendment, there is a possibility that that state's laws could apply in the state of Tennessee under the full faith and credit clause of the U.S. Constitution. We have to give honor. We have to say that another state's laws would apply here, even though that may go directly against one of our laws that we have in the state of Tennessee, if indeed the judge says the other state's law will apply. That's a choice of law argument in any litigation. One of the ways that you can attack the full faith and credit clause of applying in a situation like that, if it goes against the public policy of that particular state. This resolution establishes what the policy is of this state as it relates to a issue that might invoke a choice of law for another state's law to apply here. We would not violate the full faith and credit clause because we have this is public policy of this state. So that's what we're doing. I hope that answers your question.
Representative Parkinson.
And it did. So, and you know, I'm a visual person. So if an individual was to go and do something in Mississippi and run back over here, then and the people in Mississippi tried to apply their law to him while he's on Tennessee soil, then this resolution will point to whatever our laws say is the law of the land, and that's the laws that the judges or whoever the courts would have to rely upon versus that law that he broke in the other state.
Representative Garrett.
You're almost there.
Okay.
If a Tennessean would be in Mississippi, since you used Mississippi as an example, and Mississippi had some sort of law that further restricted the Second Amendment, which Tennessee does not believe should be the law here, that action can certainly be brought in Mississippi because it occurred in Mississippi. But if it's a company or an individual that doesn't want to sue in Mississippi and they want to sue where the defendant is found, they can certainly bring that action here in Tennessee. And what that plaintiff's lawyer is going to do, because they came here, they're going to try to influence what our laws are here on the books for the state of Tennessee and try to get the Mississippi law to apply here to a Tennessean. Under the full faith and credit clause, we would have to honor that unless it goes against the public policy of the state of Tennessee, and that's what this resolution does.
Okay. Thank you, Mr. Chair, and thank you for the explanation. Very interesting. Appreciate
Very
it.
welcome.
All right. Any other questions? Questions been called. We're voting on item number 1, HJR 131, by Representative Garrett to send to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail.
Thank you, Mr.
Civil
Chairman
full.
of the committee.
Next up is item number 2 by Representative Zachary, House Bill number 2. We got a motion and a second. Representative Zachary, you are recognized.
Thank you, Mr. Chairman and committee. Members, one of the most important and impactful bills we've passed since I've been a part of the legislature is the COVID protection bill that we passed in October of 2021, protecting the liberties of Tennesseans. In that original legislation, it was going to sunset. This piece of legislation simply removes that sunset date. Be glad to take any questions.
Thank you, Representative Zachary. Any questions? We do have one signed up to testify, Mr. Puckett. Mr. Puckett, if you'll come up to the table there, and there's a microphone. If you'll press the red button, you'll have 3 minutes. Just identify yourself to the committee, and we'll start the timer.
All right. My name is Stephen Puckett. I reside in Hendersonville, Tennessee. There you go. Sorry, the parliamentarian in me didn't catch it either. My name is Stephen Puckett. I reside in Hendersonville, Tennessee, and I am speaking in opposition of this legislation on the grounds that these protections are going to no longer be necessary due to the health emergency at the national level expiring in May. These were enacted because that health emergency created a unique situation that the state decided at a time to enact these unique protections to try to restore something what the state viewed as regular order that is no longer going to be necessary. The businesses have been well known to have plenty of time to downtrod from this and return to what's left of normal. So, they've moved on. Everybody else has moved on. Let's let this sunset and let the law move on as well. Otherwise, we're just taking up space in the code.
Thank you, Mr. Puckett, and I'll see if anybody's got any questions for Mr. Puckett. And seeing none, we'll go back in session, and we appreciate you taking time out to come today, Mr. Puckett. Back in session. Any questions for Representative Zachary? All right, seeing none, we're voting on item number 2, House Bill number 2, to send to civil full. All those in favor signify by saying aye. Aye. Opposed, no. Ayes prevail. Civil full.
Thank you, Mr. Chairman of the committee and Representative Parkinson.
And number 4 has been rolled 1 week. That brings us to item number 5, 1189 by Representative Fritz. We've got a motion and a second. Representative Fritz, you are recognized.
Thank you, Mr. Chairman and esteemed members of the committee. I bring a bill before you for your consideration today that addresses a couple things that are very important to we Tennesseans. House Bill 1189 has been evaluated and provides it's not significant for fiscal impact. House Bill 1189, if passed, would help protect those who manufacture firearms, ammunition, or components of firearms or ammunition, as well as dealers and individual sellers. It protects them from civil liability, and this bill does not apply, I say again, if the manufacturer or seller is directly involved in or otherwise accompany a person in commission of a crime, if they provide a product with a defective condition, or if harm occurs as a result of their misrepresentation. Why do we need this legislation? The 2005 Federal Protection of Lawful Commerce in Arms Act does not provide full support for these firearms manufacturers. We are in a very competitive environment in the Southeast in all industry recruitment, and this bill will help us to lead the way in Tennessee to recruit additional industry. There was a case heard in a Connecticut district court, a 7-year legal battle that resulted in a $73 million settlement against Remington Arms. This was a result of a hideous act by an individual when using a firearm. The firearms company was penalized for that, if you will. As of September of 2021, Tennessee is the #1 for employment in the firearms and firearms parts and ammunition manufacturing industry, according to the ECD. We have over 20 manufacturers of firearms parts, and ammunition, including new to come to Tennessee, Smith & Wesson, Beretta, GS Performance, and of course Barrett Arms. Passing this legislation will not only protect these companies and the employees, the Tennesseans that work there, but it will also establish an environment that encourages further investment in the state of Tennessee. This is a Second Amendment issue. It is a Second Amendment issue I offer to you because our right to keep and bear arms will be infringed upon if we cannot access those arms or that ammunition. And there are active elements that move against that today in our country, unfortunately. This is also a job recruitment bill. I'll read to you a few pieces of information regarding how many jobs this industry provides in the state of Tennessee. And this data come from the ECD. Tennessee has the largest workforce presence in the nation, over 8,000 jobs in the manufacture of ammunition, small arms, ordnance, and ordnance accessories in those manufacturing industries. 8,000 Tennessee jobs. We are at 7.3 times the national average of concentration for those jobs in our state. I think that's something we should be proud of and something that we should protect. Tennessee manufacturers produced 133,000 firearms in 2020. That ranks 17th in the nation in production number and 7th in the Southeast. I'll give you just a couple more, Chairman and Committee, just a couple more notes on our relative comparison with the Southeast because that is primarily our competition in these jobs, I think. In shotguns, we produce 16,300. That ranks 4th in the nation and 2nd in the Southeast. In miscellaneous firearms, we rank 3rd in the Southeast. In rifles, we rank 7th. And in revolvers, we rank 8th. Some of that may change with the movement of Smith & Wesson into the Maryville facility. But these are important jobs. They're important for our economy. I would offer to you that, as Mr. Jefferson said, it is the role of government to secure these rights of men. And so I offer you this bill as a protection of those rights and as a recruitment of industry to Tennessee. I'll ask for your consideration on this bill, and I'll take any questions, Mr. Chairman.
Thank you, Representative Fritz. Is this your first bill?
It is, yes, sir.
Would you care to go over all that again?
I'll be glad
No,
to.
I'm just kidding. Representative Beck, would you want to be recognized?
Yes.
You're recognized.
Thank you, Mr. Chairman. Representative Fritz, have there been any lawsuits in the state of Tennessee concerning anyone suing a gun manufacturer or ammunition supplier?
Representative Fritz.
Thanks, sir, for the question. None that I'm aware of at this point, sir.
Representative Beck.
Okay, so if we don't have a problem, why are you bringing this?
Representative Fritz.
Sir, because I do think that there is an active element to move against the firearms manufacturers. That's been demonstrated in many other states in the United States. I gave the one example there of Remington up in Connecticut. It is detrimental to those companies. Few companies can survive a $73 million settlement. As you know the history, I'm sure, of Remington Arms, that become one of the final nails in the coffin of that manufacturing company where they went bankrupt a little bit later. That name brand has been bought out again, but that creates this uproar of those people that worked at Remington. And those 8,000 Tennesseans that work in these manufacturing jobs, I think we can do something good for them here today to help protect them and promote their jobs in this state.
Representative Beck.
Just can't see the necessity of it at this time. Thank you.
We got one that would like to speak. If we can go out of session and hear from Mr. Puckett again. We'll be out of session. And Mr. Puckett will be the same as last time, 3 minutes. If you'll just identify yourself to the committee. And
Thank you, Mr. Chairman. My name is Stephen Puckett. I reside in Hendersonville, Tennessee. I am speaking in opposition to this legislation because of grave concern in really the lack of clarity when it comes to the issue of advertising and the hazard when it comes to how these weapons are marketed, because that is part of the challenge that we're dealing with. What happened in Connecticut was they sued under the advertising clause, and this and that was where they overcame. This legislation does not make it clear if a manufacturer intentionally or seller intentionally is marketing a weapon in a manner that would incite violence in a reasonable person at this point. Section A says with no intent to do harm, but it does not specify who. So we need to, that at very least needs to be clarified as to, because I don't think it's the intent. It should, I hope it's not the intent of the sponsor to allow manufacturers to and sellers to market a weapon that might imply or suggest targeting things like law enforcement, schools, or any type of label that could be applied to schools or anything else in society, because that is a serious concern and problem. Thank you.
Thank you, Mr. Puckett. And does anybody have a question for Mr. Puckett? Representative Grills.
Just as a matter of a statement, I know Mr. Fritz for a short period of time, and he would never do anything that would contribute to the destruction of a child or a family or anything. And to sit there and say something to that nature, I just think is out of order.
If I could
Mr.
respond. There was no intent in suggesting that. I apologize if that was the intent that came across. That's why I was saying I hope it is my belief that it was not his intent.
Thank you. Anybody else for Representative Catley?
Am I to understand that your main concern is the marketing aspect regarded to this bill?
Yes, because the misrepresentation aspect is what that marketing aspect is. That's what the lawsuit against Remington was based on, and it needs to be just clarified. At the very least, it needs to be clarified.
Representative Catley.
If I may, the dealer, manufacturer, or seller misrepresented the firearm, ammunition, or component part of a firearm or ammunition in a manner that could result in a reasonable person harming another person without intent to cause the harm, a person that harms another person as a result of the misinterpretation and without the intent to cause the harm, and the misrepresentation is documented. That seems pretty clear to me. I'm not seeing how that would be misrepresented.
Well, in reading that and really in hearing you...
Mr. Puckett, you're recognized.
Sorry. In hearing that and in hearing you repeat that, it sounds like those two are the same thing. And that first one doesn't seem to specify whether it's the reasonable person who doesn't intend to harm or the manufacturer doesn't intend to harm. That's where the challenge is in that.
Representative Catley.
The bill language specifically says and covers the misrepresentation by the manufacturer.
That's why
it's black and white in the language of the bill.
Mr. Puckett.
it's like it's leaving out that section of specifying whether it's the reasonable person that intends to harm in that section A or the manufacturer is unintending. That's the challenge.
Well, we can't write up legislation for unintended consequences when we've already got it in black and white in the bill. I'm not. If you could just clarify what your concern is, I'm just genuinely confused.
Absolutely, Mr. Puckett.
It's like the way that it appears to be written is that it could actually be. There's a possibility it could be actually opened up to interpretation, where the manufacturer could be protected if the manufacturer was intentional in their marketing, where a reasonable person ended up not intending to harm.
Representative Catley.
Thank you, Mr. Chairman.
Yeah.
All right, I got a question for legal while we're out of session. I just noticed that there may be an issue with a breach of contract issue, and legal, could you just sort of address that?
Elizabeth and Sonia Legal Services. Under the federal law that limits legislation against firearms manufacturers and dealers, there is an exception for a lawsuit based on a breach of contract or warranty. There's not a similar exception in this language, so I think it would be barred in Tennessee as a claim in state court.
And so that would be a policy decision that this committee would have to make, is that correct?
Whether to include breach of contract or warranty as an exception would be a policy decision for you all.
Okay, or the sponsor could roll it and amend it to make it consistent. Would that be correct, legal?
Yes.
Okay. Any other questions for Mr. Puckett? Seeing none, we'll go back in session. Well, yeah, we'll go back in session. And Representative Eldridge, you are recognized. Okay, cancel that. Representative Bullzo.
Thank you, Mr. Chairman. Thank you, Representative Fritz, for that excellent presentation. Sometimes what makes deliberating over legislation difficult is that we've got competing constitutional rights, and you have very properly pointed out that we've got a Second Amendment in the United States Constitution, but we also, in our Tennessee Constitution, Article 1, Section 6, have a right of open courts and a right to trial by jury. And my experience has been that our juries in Tennessee are not like juries in Connecticut or Massachusetts or New York or California. They're actually very responsible. And one difficulty that I have with this proposed legislation is that it is removing from civil plaintiffs claims that they currently have under our Tennessee Constitution. We are closing the courthouse door on certain types of claims. In particular, as counsel mentioned a moment ago, there are contractual claims based on representations and warranties that a manufacturer might make to a purchaser that this bill implicates and sets a higher standard than that which is otherwise required under the law. So my question, Representative Fritz, would be, why is it that the laws currently on the books, given the history that we have in Tennessee of responsible juries, are insufficient to protect the interests of both manufacturers and purchasers?
And Representative Fritz, you recognize. You'll have to turn your microphone back on.
Thank you, Mr. Chairman. Thanks, sir. Thank you for that question. I don't know that I think that our laws are insufficient at this point in time, Representative. But I do realize that we are in a mass cultural change in these United States. And that from 2010 to 2020, we had a 9% population growth in the state of Tennessee. Then in 2021, we had another 57,000 people move into Tennessee from other states. And in 2022, as I understand it from the NAR, another 82,000 people move into this state from others. And so I don't know that that dynamic of reasonableness that we rely on in your statement for a jury might be maintained, because different thoughts are going to come in. So you're going to have some number of people who think like the folks from Connecticut that will come into Tennessee. Those same statistics that I looked at for the number of people that are moving in, about 1 in 5 of those people are moving from California. And God bless them for coming here. I'm glad we have a free and prosperous state that they want to move into. But I think that if, again, we hold dear those words of Jefferson, that to secure these rights, governments are instituted among men, then we must consider that as one of our first and primary responsibilities in anything we legislate or anything we do, is securing of those rights. And holding that Second Amendment is absolute. It seems to me important here that we establish yet another protection for those manufacturers who've been willing to invest hundreds of millions of dollars in those manufacturing facilities, to protect those 8,000 employees that have made this their life's work in high precision manufacturing. So long answer to your question, sir. Great question. Thank you. I did not enter into this lightly. It is important for our rights to pursue matters in the court. I hold that dear as well. I just think that maintaining those basic rights, those civil rights that our founders wrote into our Constitution and then into our Tennessee Constitution are tremendously important. And it became a balance of weight for me as I worked on that legislation. So I hope that answers your question. Thanks, sir.
Representative Lambers.
Oh, thank you, Mr. Chairman. Gentlemen, this is a wonderful back and forth, and I know the rest of us have deeply enjoyed it, I can assure you, and I mean that seriously. It's really good stuff. I do think what legal said has brought up a very interesting point on warranties and contractual issues. Would you be willing to roll this a week just to work on that particular issue? Because I do think that, and I'm a huge fan of the legislation. In fact, I've already signed on. I don't want frivolous lawsuits against our firearm manufacturers just because they make firearms. But would you be willing to roll it a week to work on the other two kind of clerical issues that I do think need to be addressed?
Representative Fritz.
Absolutely, yes.
Wonderful.
I'd be happy to.
All right, without objection, item number 5, House Bill 1189, rolled 1 week.
Thank you all so much.
That brings us to item number 6, House Bill 1367 by Representative Farmer. We got a motion and a second. Representative Farmer, you're recognized on House Bill 1367.
Thank you, Mr. Chair. Members, this legislation amends 2 statutes related to opioid settlements to allow for settlements with 5 additional companies to be treated with the same agreements with the 3 national pharmaceutical distributors, Johnson & Johnson. A little background, the original legislation passed in 21, Public Chapter 491 established the state's opioid abatement trust fund, created the opioid abatement council, and mandated the allocations to counties and released claims addressed by the settlements. So long story short, what we're doing here, we're going to amend that statute to add these companies in for right at another $490 million to be allocated throughout our state. So this is what that does. If you guys have any specific questions, I'll be more than happy to answer those, but otherwise I just move passage.
Move previous question.
Previous question's been called. All those in favor for voting for House Bill number 1367 to send the full signal, signify by saying aye. Aye. Opposed, no. Ayes prevail. Civil full. Next up, item number 7, 1355 by Representative Farmer.
Motion.
We got a motion and a second. Representative Farmer, you're recognized.
Yeah, thank you, Mr. Chair. Members, House Bill 1355 is supported by the Tennessee Bankers Association, Tennessee Mortgage Bankers Association, and Tennessee Credit Union League. What we're trying to do is modernize the state foreclosure process and help struggling homeowners, Tennesseans, financial institutions, and investors. The major component of this bill is the creation of a user-friendly website by the Secretary of State to host all public notices of foreclosures of Tennessee. This will ensure that these notices are accessible to everyone at no cost 24/7 in the 20 days leading up to the sale. The portal will be user-friendly and word searchable, making it easier to locate information about foreclosures throughout the state to anyone wherever they're located. For the first year in 2024, all notices will continue to be published in a newspaper and online. And after that, notices will be online only. However, if a deed of trust superficially requires publication in a newspaper, the notice must be published both in newspaper and online. By transitioning to a single statewide portal, information about foreclosures can reach a much wider audience, which will reduce deficiencies owed by borrowers and support stronger home values for the community. This will also significantly reduce costs for publication for homeowners, and most importantly, it will only affect the public's notice of foreclosure. The borrower will continue to be mailed notices of the foreclosure sales via direct registered mail. And quickly, the bill also removes the antiquated requirement to announce continuances of sales at the courthouse steps, instead allows for posting the continuance online once the Secretary of State's website is live, requires that borrowers be mailed a notice of every continuance. This is important. Currently, if a continuance is less than 30 days, the borrower is not given notice via mail. This would. It also provides that a penalty for failure to comply with these terms of the deed of trust does not result in a void or voidable sale. And I wanted to go through that to know what it did. I've read from my notes here, but if anybody has any questions on this, I'll be more than happy to answer those.
Representative Beck.
Thank you. And Chairman Farmer, I apologize for not talking to you about this before, but the Bankers Association came and talked to me earlier today, and after speaking with them, I really liked their idea of a centralized place to look for the foreclosures, because a lot of people are confused when they get foreclosure papers, whether they're even in foreclosure. It's very odd. But then the newspaper people came to talk to me, and they said there is already a website where you could, which was news to me, that you can go in and locate any notices that have been filed for a foreclosure that have been published in any newspaper across the state. Public Notices Tennessee, which I wasn't aware of. And my understanding is there going to be a fee with the Secretary of State, Chairman?
Representative Farmer.
Thank you, Mr. Chair, and thank you for those questions. Yes, there's a fee. There's a $200 flat fee on these notice publications. And with regards to the online publication that already exists, it does, but it doesn't exist statutorily. That means it could dissolve at any point in time. There's no reliability or consistency there that we can rely upon. By creating this and making it the law, the Secretary of State would be responsible for keeping this in place. So I think having this ran through the Secretary of State's office versus an association's online website that we have no control over, and it may be there today, may not be there tomorrow, is potentially an issue. Not say that's going to happen, but it certainly could. So there's the issue there. And then also, I've had some members express the concerns, 2 or 3 come up and say, look, I don't have internet in my community. How are my homeowners going to find out about this? And frankly, this is just procedure. At the end of the day, a homeowner that's in foreclosure is going to be given notice by their bank directly. They don't receive this notice from the paper. So if you're in foreclosure as a homeowner, the first place you find out about it's not going to be in your local newspaper. You're going to be in this process for months at a time, and then you're going to end up in the foreclosure process. Really what this does, the notices in the paper are there to provide, at some point in time, marketable title for these properties. So by law, it requires for these to be ran in the papers to provide notice, and then so the underwriters will then provide title insurance on these properties for the foreclosure sales. And it wouldn't necessarily be the borrowers that'd be looking for this. It'd be other investors to come in to try to buy these properties, to try to, where the homeowner, unfortunately, maybe another homeowner may even buy the property. So I think it's mostly procedure having these in the paper. I don't think it's really substance over form here with regards to delivering marketable title at the end of the day. So I don't think this would hurt the homeowner in a negative way, much if any, by giving any sort of notice. And plus your mailed notice here. If something is reset, they're going to mail it to your address. So that's also in this bill. So I hope I answered your question. I know I went a little beyond it, but I think a reliability standpoint is really what it comes down to.
Representative Beck.
Okay, I appreciate the explanation. I'm still a little in the gray area on this. It seems like we're taking we're taking from private companies and giving the obligation to the government to. I'm not sure if it takes $200 an ad on an online basis, but thank you.
Representative Eldridge.
Okay, thank you, Mr. Chairman. And Chairman Farmer, I know, I've expressed some concerns about this too. Up in our area, there's a number of small newspapers up there. I can probably name you all 5 or 6 right now. That to me, we are taking that away from a private business, a company that is a part of our community right there in Morristown. Is one in particular, Granger Today, Greenville Sun. There's in Claiborne County Progress, and a lot of those areas are not served by internet yet. They're working on it. We've made a lot of effort down here to do that, but there's still a number of small communities up there. And it's not, and I realize that the property owners are notified that there's if there's a problem, if they're in foreclosure. But I think the notice also goes to possible investors and purchasers of that property at some point that may or may not have access to that internet. But to me, we are establishing another government, program that's going to replace private companies up there, and those companies employ quite a few folks, and many of them that I know have been with the paper for 25 or 30 years, and they're kind of like me. They're getting a little long in the tooth, and where else are they going to go? But I'm just not ready to put that nail in that coffin for them. They rely on the notices. as a part of their income. I think it's still a needed process for right now. Maybe it'd be something that you do a hybrid. And I know that was mentioned for a year, but I just don't think that's an adequate time. So I could not support this at this time. Thank you.
Representative Farmer.
And Representative Eldridge, I know you had expressed that to me, and I appreciate your comments. Thank you.
Anyone else? Representative Todd.
Thank you, Mr. Chairman, and I really appreciate the legislation and the way it's crafted. You've got a period of time for folks to work into this and for the system to adjust. But my biggest, like in this is that the consumers, the folks that are being foreclosed upon, are going to be burdened with less cost to get back in their homes than they are now. Right now, this could add, this could double or triple what their actual payoff for that, to get them out of foreclosure would be, and it ends up prohibiting them from doing that. So I like that aspect of it. I've had folks over the years in similar situations that when they were faced with this situation, they might have had the money to get them out of foreclosure, but they couldn't take care of all of the other costs, the legal costs and the notification costs, because they are substantial. And of course that varies with different newspapers, but it can be, $1,500, $2,000 or more. And that, I think this goes to get, I think, at what most of us would want to happen, and that is for folks to be able to stay in their homes. If they got behind, they get caught up and move on with life. And the lenders, I think, would come out better that way as well. So it's better for the whole system. So I appreciate you bringing this. Thank you.
Thank you, Representative Farmer. You got any further? All right, seeing no questions, we're voting on House Bill 1355 to send to civil justice full. All in favor signify by saying aye. Noes signify by saying no. Ayes prevail. Civil full. Next up, item number 8, House Bill 1158 by Representative Todd. We got a motion and a second. Representative Todd, you are recognized, and we do have an amendment.
Thank you, Mr. Chairman. Yes, we do. Amendment Drafting Code 3933.
That's what I showed. We got a motion and a second on the amendment. We got a motion and a second. Representative Todd, you are recognized on 003933.
Thank you, Mr. Chairman. The amendment makes the bill, and what this does, basically 4 tenets of this bill, that because of the complications of our code dealing with firearms and handguns, it has to touch a lot of pieces, and so it has a lot of sections in it to clean up what we already have, which I firmly believe are infringements on our Second Amendment rights, our civil rights in this country. Does the first thing, it lowers the age from 21 to 18 that for a person to have a permit in the concealed permit section and also enhanced section. It will change that to firearms, actually, instead of handgun. That's one of the other things it does. But the 21 to 18 has already been litigated in court. The state was sued, and the state has agreed, and that order should be signed maybe even today, I understand. But in the federal Eastern District Court, with respect to the Second Amendment rights for 18 to 20-year-olds, and our Attorney General agreed in that, and one of the statements out of that case, out of the agreement, is that and I'm going to paraphrase here, the scheme regulating the possession and carrying of handguns for 18 to 20-year-olds violates the Second and 14th Amendments to the U.S. Constitution. Many of us have been saying that for some time, but getting that changed has been difficult. So the court has pretty much mandated that we do that now. The other thing that we do, this is a pretty major thing. Most people in this state don't realize that we have a provision in our code that says in 3917-1307A that it is an offense to go armed with a firearm or a club. And when you talk to people about their carry permits, they'll say, no, I've got a permit. It's not a violation. No, it technically is still an offense, and this cleans that up. Also changes the references to handguns for the permitting and constitutional carry to firearms. And then one last thing it does, and this is in Section 21 of the bill, it clarifies that what I believe is already implied in 3917-1325, that it states currently that an immunity from civil liability exists if you do not post your property as a gun-free zone. And so I believe that implies that that immunity wouldn't carry forward if you do post. And so this clarifies that, just makes it very clear. So a very minor tweak there, I believe. A concern that, and I want to get this on the record of what my intention is here. My intention is for this to apply to adults, 18 and up, and that it also not change anything with what we do currently with hunting and shooting sports and that type of thing for minors. So I don't want to have any effect on our law when it comes to hunting or sporting things with firearms. So there may need to be a tweak to this and I'll get with legal. I attempted to today and we weren't able to make a connection. To clarify, I was under the impression that a U.S. code actually applied there, but I'm finding out that's not exactly what I interpreted. So I'm fine with it applying, and I plan for it to apply to 18 years old and up, which are legal adults. Even with one caveat, I will mention that under U.S. Code 10 U.S. Code 246 actually sets the age for the militia in this country at 17 years of age and up, and that's our federal law. But barring that, I'm certainly in favor of making sure this applies only to adults 18 and up. With that, I'll be glad to take any questions.
So would anybody have a problem with adding the amendment now? All right, we'll be voting on Amendment 003933 to add to House Bill 1158. All those in favor signify by saying aye. Aye. Opposed, no. The ayes prevail. Amendment's added. Anybody like to be recognized? Representative Beck.
Thank you, Mr. Chairman. And sponsor, let me get straight what all we're doing with the amendment that was just adopted, 3933. By replacing handgun to firearms throughout the code, what is it your intent, or would this allow a person to carry a rifle in open public, such as up and down the sidewalk in front of our building?
Representative Dodd.
I believe that is their constitutional right as it stands right now, and our laws, our combination of laws, are in violation of that civil right.
Representative Beck.
So if I want to carry an M16 or an automatic or semi-automatic rifle up and down the road here in front of our building, if this became law, that would allow me to do that. Is that correct?
Representative Dodd.
If this became law, we would join 44 other states in doing that.
Representative Beck.
So that would go for any public street such as Broadway or anything else in within city limits, correct?
Representative Todd.
Thank you, Mr. Chairman. It would be correct. And for almost the entirety of this country's existence, arms that were seen were not a problem. Concealed arms for a long, long time were very much a problem. But having it open for the public to see wasn't a concern to people. They knew where they were. They knew what they had there. So, yes, you are correct.
Representative Beck.
Okay, and let me get clarification. I've read this sentence several times, and I'm still not clear on the civil immunity. So if this amendment and this becomes law, what is your intent on the civil liability? Is presently, can you just explain to me what your thoughts are and your intent, please, sir?
Representative Todd.
Certainly. Thank you, Mr. Chairman. So currently, the law states in 39-17-13-59 that immunity from civil liability exists if you do not post your property as gun-free, or TCA code, the placards that you're supposed to put up having your property as a gun-free zone. that immunity applies if you do not post. I assume from that, that would mean if you do post, that immunity doesn't apply. It doesn't mean you're liable, but it means you don't have the immunity that's guaranteed in 1359. This just clarifies that. This just said, if you do post, the immunity doesn't apply. It leaves that, kind of takes the ambiguity out of that.
Representative Beck.
And what was your interpretation of what that immunity was, if that we're changing?
Representative Todd.
I'm not going to get into what that immunity may mean. I'm not sure what that means, quite frankly. That's a legal matter that I think that would come before a judge to say, okay, if you meet these qualifications, immunity applies.
Representative Beck, you recognize.
Could we go out of session and get a clarification from legal exactly what they believe that would mean in this legislation?
Yes, sir. We'll be out of session. Legal, you recognize.
So the new language would state, a person or entity who is authorized to prohibit the possession of firearms on the person or entity's property pursuant to 3917-1359, and who elects pursuant to that authority to prohibit the possession of firearms by a person lawfully carrying a firearm, is not immune from civil liability with respect to a claim based on the person's or entity's adoption of a policy that prohibits weapons on the property by posting pursuant to 3917-1359.
Representative Beck.
So this immunity is just going to the immunity that was granted if you posted that guns were not allowed on, say, this property, like a college classroom or something. So we're saying that before they were granted immunity if they posted that sign. Is that? I'm having a hard time following this. Can you help me out?
Legal, you recognize.
Well, colleges would be under the school statute, so separate from this. They're not able to post. So the current immunity in 3917-1325 states, a person, business, or other entity that owns, controls, or manages property and has the authority to prohibit weapons on that property by posting pursuant to 3917-1359 shall be immune from civil liability with respect to any claim based on such persons, businesses, or other entities' failure to adopt a policy that prohibits weapons on the property by posting pursuant to 3917-1359. So they have immunity from a civil claim that an injury was due to the failure to prohibit weapons on the property. And then subsection B goes on to state that the immunity does not apply when the failure to act is the result of gross negligence or willful and wanton conduct.
Representative Beck.
Very good. So in that same, when we pass that, we also pass the entities that could be post signs of not to have a firearm on that property. For example, my libraries. Are the libraries still going to be able to post the sign that no firearms are allowed on the property?
Legal, you recognize.
Yes, this won't change their ability to post, but if they do post, then this new language that states they do not have immunity from civil liability would apply to them.
Representative Beck, you recognize.
I got it. Thank you so much.
Anybody else got a question for Representative Parkinson?
I don't have it. Can you, in layman's terms, not lawyer's terms, please?
Legal, you recognize.
So the current statute 3917-1325 states that if you have property that could be posted, so basically any private property generally, and you choose not to post, you are immune from a claim based on the fact that you chose not to post, unless that choice was gross negligence or willful and wanton misconduct. Okay. And this language would add that if you choose to post, you are not immune from civil liability. So if you choose not to post, you have this immunity. If you choose to post, you do not have immunity.
Representative Parkinson.
Okay, thank you for that. Thank you for that. I have much more clarity. That's a flip. Got it.
Thank you. Anybody else for legal? Seeing none, we'll be back in session. Representative Beck, do you have a follow-up for Representative Todd?
No, thank you, Mr. Chairman.
Thank you. We do have one that would like to testify today, Miss Kathy Barnett. We'll go out of session. Miss Barnett, if you'll come up to the table, just make sure your red microphone light is lit up, and if you'll just introduce yourself to the committee, you'll have 3 minutes.
Okay. Can I first address Representative Beck and ask a question to clarify something?
No, you'll have to address the chair, and we'll listen to you for your 3 minutes.
Okay. Hello, I'm Kathy Barnett of Moms Demand Action, Tennessee. I'm a mother, grandmother, and a retired teacher. Like many fellow Tennesseans, I'm against House Bill 1158. This bill allows people 18 to 20 years old to carry a loaded handgun in public without a permit. It also allows them to obtain an enhanced or concealed carry permit. Scientific studies clearly show that the human brain is not fully developed until about the age 25. Though legally we treat them as adults when they turn 18, voting, military service, marrying without permission, these studies show that teenagers are not mature enough to make split-second life and death decisions with a gun. Impulse control is a behavior that teenagers are still learning. Adding guns to the mix is dangerous because the result is more injury and more death. We know from research and what happens when you add guns to incomplete brain development. 18, 19, and 20-year-olds commit gun homicides at a 3 times higher rate than adults. The rate of gun death in Tennessee increased 52% between 2012 and 2021. These are the facts. To ignore them will cause more gun injury and deaths. So the question cannot be ignored or swept under the rug or lied away. Why do you want to make things worse? It is true that we include 18, 19, and 20-year-olds in our military, where they are provided with extensive firearms training. But the hard, cold military fact is that young soldiers are taught to follow orders from their officers who are not 18, 19, or 20 and are instead full adults. This is because of what the military has long known from hard, practical experience. Young soldiers don't get to decide when to shoot. Instead, they are told when to shoot, so that when they shoot to kill the enemy, not each other or us, the American people they are trained to defend. This is why Chairman of the Joint Chiefs of Staff, General Mark Miley, has said, "I don't think soldiers should have concealed weapons on base. Something tells me General Miley would not think letting kids store guns in the high school parking lot is a good idea either." And then there's suicide. Youth suicide has increased almost every year since 2007, and it's getting worse. In 2021, suicide was the second leading cause of death among Americans aged 10 to 24. Each year in Tennessee, roughly 93 young people end their lives with guns. This bill puts more guns in the hands of young people who may be at risk for suicide due to childhood abuse or other trauma. So I ask again, why do you want to do this? This body is charged with advancing the safety and public welfare of Tennesseans. Those of you who support House Bill 1158 must be aware that we are presently...
Ms. Barnett, thank you for your testimony. It's 3 minutes, and we do have time for follow-up questions. Do we have any questions for Ms. Barnett? Representative Bolzo.
Thank you, Mr. Chairman. Thank you for your presentation, Ms. Barnett. It's very impassioned, and I can tell that these are heartfelt comments that you're making. But let me ask you this. Do you recognize a distinction between whether it's a good idea to allow 18-year-olds to have handguns and whether or not the Second Amendment requires that states allow that?
Ms. Barnett, you're recognized. You had to press the button.
I feel that we agree with the Second Amendment, but I think that we have to be safe as well. We have to have common sense. And, you know, Anybody who's lived with a house of teenagers knows that that is not a good idea to put a handgun in their possession. It's just going to lead to something dangerous happening, and I think it's not going to keep our citizens safe in Tennessee. Bottom line, most Tennesseans don't want this.
Representative Bolzo.
Yeah, thank you, Mr. Chairman. One follow-up. Are you aware, Ms. Barnett, that our Attorney General, General Jonathan Scrimetti in Tennessee, in the Beeler case, has recognized that Tennessee's current statutory scheme is unconstitutional, and that what Representative Todd's bill is doing is bring Tennessee law into compliance with the Second Amendment?
I was instructed that that was not determined yet, that has not been resolved.
All right, any questions for Ms. Barnett? Any others? Representative Beck.
Thank you, Ms. Barnett, for being here. My question to you is, did you have in your statistics the rise of handguns being stolen from vehicles since we've loosened the restrictions on having guns in our cars and on our person?
Yeah. We do have that. I don't have it off the top of my head, but it has gone up tremendously each year. And more young people are committing these crimes because it's easy to break or to get into a car that's not locked. And so I mean, a lot of police are begging us to repeal this law. It has not been safe. It's caused a huge problem. And I can get you those statistics, but they have gone up quite a bit.
Representative Beck.
Thank you, Mr. Chairman. In talking with my local police, it's just mind-boggling how many people with firearms leave their vehicles open. And it's created a whole culture of these youth just going around checking. They don't even have to break the windows. They just check the doors. And in my district, people in the whole city and in the whole state, I imagine, are just leaving their doors open. And we're getting all these stolen firearms on the street, and so many of them being caused in horrible crimes. So I understand your testimony, and I understand the plight that people are in. Thank you very much.
Thank you.
Leonard Lambers.
Thank you, Mr. Chairman. So, ma'am, I've listened to your testimony there, and I've heard you folks from your organization testify before. So at what age are you comfortable with folks possessing firearms?
21.
Okay. And why 21? I know that's what the law is now, but why 21? You said earlier 25, individuals' brains are fully developed, and I've seen the research on that out there as well. So why 21?
Ms. Barnett, you're recognized.
I don't really know why. I think that's just the age that most people feel it's the right time.
Well, ma'am, I wasn't really asking what most people thought. I was just curious what your personal opinion is. You've taken time out of your day. You could be anywhere else in the world, and this is important enough to you to come down here and testify. So I would just
I will tell you this. I've raised 18-year-olds, and I feel like 18, 19, 20, those are very transitional years for our youth. Some of them still in high school. Some of them haven't graduated yet, but they're trying to decide what they're going to do with their life. Okay, some of them may go into the Army or Navy or forces. Some of them don't know what they're going to do. They're in college. They're trying to figure what their life is going to, what direction they're going in. I think it's a very transitional time, and sometimes they just don't know. They don't have a good sense of what they're going to be doing in life. And I don't think that's a good time to be, they're leaving their parents at that time. They're making their own decisions. They've been living with their parents up until that point. And I think by the age of 20, 21, they're more mature and they're ready to go on with life a little more.
Luder limits.
Thank you, Mr. Chairman. And I can understand that's the reason I always ask folks that come before the committee what their personal opinion on stuff is, because we just have different life experiences. And I will admit, a lot of the folks from my community, they spend their formative years, K through 12 education, preparing for a career. I have a nephew that's making six figures plus right now as a lineman. He's 19 years old. Quite frankly, I'd be pretty disturbed if he was not able to carry a firearm with him and some of what he does. So, I mean, can we at least agree that while I'm not disagreeing with your personal experiences and what you've seen from folks that may be going off to college or something else, that there's a whole lot of folks at 18, they become adults and they get a job, they get married, they have kids, they start life. They're adults. Is that fair enough?
I agree. There are some that are like that, but I think the majority aren't.
Okay.
That's just my opinion.
Luder limits.
And ma'am, I respect your opinion. That's why I was asking for it. It's not a gotcha question. I asked for opinion. You're here to share it with us, and I appreciate it. So let me ask this. This is kind of my final question here. If we know that there's some 18-year-olds that obviously they're old enough to sign contracts and get married and fight and die for their country and bleed for their country, if we know that there are some out there that are like that, then when we're talking about constitutional rights, isn't it fair enough to at least allow those 18-year-olds that have not stolen guns, that have not committed felonies, that have not been mentally committed to an institution, that they're adults, that we would not recognize them as such and trust them to exercise their constitutional rights as our forefathers provided for them to be able to, and not treat them like they're still kids?
Ms. Barnett, you recognize?
I mean, I don't think you can pick and choose at that point. You have to have a law that applies to everybody. And basically, if you're looking at most of those young people are not really mature enough to carry a gun, and it can be dangerous, I feel like the law should apply to everyone.
Well, thank you, ma'am. Mr. Chairman, my final comment, I guess I just have a little more faith in our younger folks than you do, but I met a whole lot of them at 18 that are really good folks, and they're very mature, and they do a fine job. Now, look, I get it, some of them are not, but when they turn 18, they're adults, and I trust them to make adult decisions. But thank you, ma'am. I really appreciate it, and thanks for visiting with us today.
Okay. I mean, I'm not saying that there aren't 18-year-olds that are like you say, but anyway.
Representative Kepley, you recognize?
Thank you very much for coming up here today. So you do believe that 18 years old is the age of an adult. We can agree on that, correct? When you turn 18, you are an adult.
I think you're still a teenager.
But are you an adult? That's a yes or no question.
In the eyes of our society now, I guess you are an adult, yes.
So when you turn 18, you're an adult. So when you turn 18, you can enlist in the military, and Tennesseans can go overseas and fight and die for this country. But when they come back to Tennessee at 18, you're saying that they're not able to carry a firearm in their home country. Is that correct?
You have to have a law that applies to everybody, okay, whether they're in the military or not. There's still, as I explained in my testimony, when they're young and in the military, they are under the direction of their captains, the people that are above them, so on and so forth. So I still think that they should be in that same category with everyone else that are under 21.
So they can go overseas and die with a firearm in their hands, but as long as they're here in their home country, they're not supposed to have that ability.
As I said in the testimony, I think 18, 19, and 20-year-olds are not mature enough to carry a gun.
I'm 25. I'm the youngest member of this General Assembly. I have had a gun since I was 8 years old. Some of my most fond memories of my entire life is going through the woods with my uncles, my brother, carrying a firearm. I have never once in my life thought about picking up a firearm and using it maliciously. All my friends, my family, never once had an issue.
That's great. I have, a brother-in-law that raised his 2 sons to hunt as well, and I have nothing against that.
All right, we're out of time. Ms. Barnett, I appreciate you being here. Appreciate your service as a teacher, and we'll go back in session. And if you'd like to come back next week to testify, just be put back on the list again. We're back in session. All right, that brings us, we're still not done. We'll roll everything till next week, and same time, same place, and we will stand adjourned without objection.